married father was killed, and the man responsible was sentenced to just over 5 years in a UK prison, with eligibility for release after around 3. Like many people, I thought this sentence was far too lenient, so I decided to investigate how the law arrived there. The facts of the case are that the victim, Andrew Clark, was involved in a brief confrontation inside a Sainsbury's supermarket after Demish Williams queue-jumped. The argument ended and Williams initially left the scene. He later returned wearing a balaclava and he struck Clark once with an open hand to the head. Clark fell backwards, struck his head and suffered catastrophic brain injuries. He died in hospital 3 days later. Williams pleaded guilty to unlawful act manslaughter and was sentenced to 5 years and 3 months in prison. Under the current release rules, he is likely to be eligible for release after serving around 3 years, subject to licence conditions. You may be wondering why this wasn't murder. And to answer that, here's some basic English law. Murder requires proof of an intention to kill or cause really serious harm. That intention must be proven beyond reasonable doubt. Single blow killings sit on a difficult legal fault line, if you will. There are cases where a single blow has resulted in a murder conviction and others where it hasn't. The difference is the nuance of each case and what a jury can be sure the defendant intended at the moment the blow was struck. In this case, to pursue a murder conviction, the prosecution would have had to convince the jury that Williams intended to kill or cause really serious harm. But the defence would argue that it was a single-handed open strike, a serious and reckless act no doubt, but not one intended to cause such extreme injury. Introducing even reasonable doubt on intention alone would be enough for a jury to reject a murder conviction. So, faced with that evidential risk, and following Williams' guilty plea to unlawful act manslaughter, the prosecution accepted the lesser charge. But what is unlawful act manslaughter? Why was that accepted? Unlawful act manslaughter sits between murder and pure accident. It applies where someone causes a death while committing a criminal act, even if they never intended to cause any harm. In this case, the unlawful act was the assault itself. Williams intentionally struck Andrew Clark. That is a criminal act. For unlawful act manslaughter, the prosecution doesn't need to prove an intention to kill or cause serious harm. The legal test is far simpler. They must show that the unlawful act was one that all sober and reasonable people would recognise as carrying some risk of harm, and that the act caused death. Hitting someone in the head, even with an open hand, clearly carries a risk of some harm. When Clark fell, struck his head and later died, that risk tragically materialised. That's why unlawful act manslaughter fits the facts of this case. But they never needed to put these facts to a jury, as Williams pleaded guilty to that offence. And once the plea was accepted, guilt was fixed. The only question left was for the court to decide how long the sentence should be. Which begs the question, why was the sentencing so lenient? This is the part that many people struggle with, because the sentence feels disconnected from the harm. There are many steps to calculating a sentence, but I'm only going to cover the main ones here. Under the sentencing guidelines for unlawful act manslaughter, the loss of life is already taken into account. What separates one case from another is what the offender intended, and how serious their conduct was at the moment of the act. Emphasis is given to the blameworthiness of the offender. Here, the court wasn't satisfied that there was an intention to cause very serious injury, so that placed the case roughly in the middle guideline, likely range C. That would give a starting point of 6 years and a range of 3 to 9 years. From the starting point, the court then has to adjust the sentence to reflect aggravating and mitigating factors. Aggravating factors could include returning to the scene wearing a balaclava and striking the victim in the head, also fleeing the scene shortly after. Mitigating factors could be that the offender had no prior convictions. So once the court adjusted the sentence based on the additional factors, it then had to apply a mandatory reduction for an early guilty plea. When all of those steps are followed, the result came to a paltry sentence of just over 5 years. It's also worth noting that concerns have been raised about prison overcrowding in the UK, with the victim's wife suggesting that capacity pressures may influence sentencing outcomes. That issue sits beyond the scope of this video, but it does form part of the wider debate. We now need to consider, how could this be appealed? The sentence is actually being considered under the unduly lenient sentence scheme, following calls for a review, including from senior political figures. The UK Shadow Justice Secretary Robert Jenrick has written a letter reflecting the concerns of many. He describes the killing of a man over nothing, He points to the deliberate return to the scene, an assault on a man who posed no threat, and violence that created an obvious risk of injury. Those factors, he argues, indicate a higher level of culpability than the court applied. If accepted, that assessment would move the case into a higher culpability category under the guideline, resulting in a substantially longer sentence. On that basis, the sentence could be reviewed and potentially increased. However, the idea that someone could be released after around 3 years, having caused a man's death in a violent confrontation over nothing, feels deeply wrong. So, the question this case leaves us with is this: did the court get culpability wrong, or did it apply the law exactly as it stands, even though the result feels deeply unsatisfying? If the court got it wrong, that should be corrected on review. But if the culpability assessment is upheld, does that suggest a system that is no longer aligned with what the public expects justice to look like? And that raises a final question: are the current release rules fit for purpose in cases where someone has caused a death? What do you think?